Judiciary Committee, and we have one item to look at this afternoon. It's an amendment to S-109, and we're going to have a legislative counsel walk us through the amendment. It should be on everybody's desk, I believe. It is, yes, yeah. Start. That was good.
Good afternoon, everybody. Eric Patrick with the Office of Legislative Counsel, here to walk the committee through a proposed amendment to S-109, the miscellaneous judiciary bill. I heard the chair say that you should have the amendment. I just want to make sure before I start talking about the substance that everyone actually does have the language in front of them one way or another.
Just print out the short portion. Yes, it's a short 2-page. It's draft number 1, 9:37 a.m. We talking about the same thing?
Yes, exactly.
All right.
Yep. And so it is an amendment to the miscellaneous judiciary bill. So you could, if you wanted to sort of toggle back and forth, look at the version of the underlying bill that's being amended is version 8.1 of S-109. Now I'll explain as I go through it. So it's not 100% necessary that you have both, but if you want to have both and want to look back and forth at the language, that's the one that's being amended.
Sorry, what was the draft number of the?
8.1, yep, of the
Thank you.
committee amendment. Committee strikeout amendment, I should say.
Yep.
Which brings me to the first typo in the amendment. In the amendment on line 2, you'll see that at the moment it says the representative Lalonde moves that the House proposes to Senate that the bill be amended. Should be that the proposal of amendment be amended. It's not actually
It's not
a bill still. You're right. It's not just typo. It's really just a substantive mistake, but I appreciate that. You're right. I can't really fall back on the typo, unless it really is a typo. So yeah, no need to apologize. It won't be the last time. So yes, I should say, although it's interesting, I feel like whenever I put bill and then whenever I put proposal of amendment, no matter which one I do, the editors correct me. They change it. So it could be, I'll change it now and then they'll change it back.
Don't blame the editor.
Yeah.
It's almost all beautifully.
Yes, almost.
It is beautiful.
I appreciate that. So moving on to first proposal of amendment, actually strikes 2 sections, sections 22 and 23, and those are the public inebriate provisions. Remember that what went on in the underlying bill was that you repealed the sunset essentially on the public inebriate law, and that was the idea that public inebriates can't be housed in Department of Corrections facilities. Now, the reason that's being deleted here is because the same language already passed and is on the way to the governor in S-36.
And you left it in here until we understood that it.
Right.
No. It's about the Barbara.
So that's just struck from here because it's in another bill and it's already heading passed. But the Senate concurred in the House proposed changes in the House Human Services recommended by the House Human Services Committee. The one slight language change that they made was just not a substantive one, but referring to, rather than public inebriates, they put in persons who are incapacitated, and that actually is a technical fix because the underlying statute does use the phrase. It used to say public inebriates, but that more recently that was updated to persons who are incapacitated. So in terms of the sunset language, it was just sort of truing that up. So that's the only difference. So those sections are deleted. You notice that they aren't actually struck because in order to preserve the numbering of the lengthy miscellaneous bill, we just delete them. So you still will have sections 22 and 23 in the bill. It'll just say deleted afterwards. So that way, internal cross references or effective dates, that kind of thing, you don't have to, that's oftentimes where inadvertent, where actual typos do show up sometimes. So we just keep the numbering the same. All right. So that's the first instance of amendment. Second instance of amendment adds new sections 25A and 25B. You'll see the new language there. They are referred to as 25A and 25B, both for the same reason, keep the numbering the same, but also in that particular spot, because this relates to section 25 in the underlying bill. And that was, you may recall, that was the issue of the DCF had come in and testified. It was the repeal last year of language involving prohibiting the consideration of a person's prior child support payments or lack of having made payments when a decision is being made in an adoption proceeding about someone's parental rights. And remember, some private practitioners testified, well, hey, that actually someone's prior history might well be relevant in a proceeding that's not involving the state. This is a proceeding that's involving parents litigating over who might be the best parent for a child. And in that case, it might be relevant if one of the parents has or hasn't paid child support in the past. So that language is put back in. But you may recall the DCF witness you had said that their view was that they were going to work on language because they thought it still would be relevant in a different situation when DCF is trying to terminate parental rights. I'm sorry, that it wouldn't be relevant. That in that case, because the issue when the DCF is doing it isn't between the parents, it's whether there's been abuse and neglect of the child. And in that case, person's economic status isn't relevant. So that's why you have the language here that they'll say, all right, so these are different statutes being amended, not the one that's in the underlying bill, which was the adoption proceeding involving just the parents. This one is the TPR by DCF. And in those cases, the proposal is to add language you see in lines 14 to 16. In those situations, the court shall not consider failure to make payments to DCF for the support of the child as a factor in making a determination about TPR. My understanding is that the same private attorney who was concerned about it in the previous context looked at this language and is okay with it here because this is a different type of proceeding. It's DCF TPR proceeding, not a determination of parental rights between the parents themselves. So that was the language they came back with. Yeah, I think they said they were going to try and work on language and come back with it. This is it right here. And all right, so moving on to
Just, I think really quickly, it was run by Kurt Hughes.
Yeah.
I think that this language was run by them or by Kurt, and he was fine with it.
Yeah, that was that who we heard from the first time on this?
Yes, correct.
Yeah, because I think if I ask you a question,
Yeah.
my only concern would be just that I think the point was well made. We heard the testimony before that like payment of child support could be something considered as far as like best interest of the child. And so DCF is sort of splitting this. They're asking to sort of split this and say that they can consider payment child support, but they're not going to consider failure to make payments of child support to be termination factor for termination of parental rights. Is that the intention?
Deferring to DCF and what they suggested. I mean, we can get DCF in to.
I'm just wondering that like it's just very specific that they're saying only the failure to make payments.
Right.
Okay.
And
Yeah, go ahead.
if I recall, it was because they wanted to like just spell out a practice, which is that lack of financial resources isn't going to like lead to termination of parental rights.
Yeah. Yeah.
So yeah, I think you're right that the fact that it says failure to make payments is intentional. I don't know that they said they would consider payment of that, but
Yeah.
it was really stressing that it's not, you're not going to be penalized for being,
Oh, I see.
for not having money.
Yeah. Because I think the point was that the other party, not DCF, would want to argue, look, my person is paying.
Yeah.
So this should be considered. So this would allow that still in a TPR, presumably. Well,
And I've got to say, it seems relevant if somebody cannot pay or is not willing to pay. And some of it seems like it speaks to neglect of a child. I mean, so I don't know.
They're saying they don't want to consider it. I don't want.
We can, I will, get DCF to come in tomorrow to explain it to us. And what their point is.
Yeah.
Way back when it made sense, but, I'm hearing that there's some, concern, so. let's do that. So, Nate, if you could reach out to our DCF people, Nellie, and say we need somebody to weigh in on the, S-109 amendment. The language that they provided. Tomorrow afternoon. All right, over to you, Eric.
Yes, already. So moving on to the third and fourth instances of amendment, page 2, lines 3 and 5. These were both requests from the House Corrections and Institutions Committee. This is you may recall these sections were related to subtopics that they deal with anyway, having to do with the earn time. Remember, the first one involved earn time. The first one is a purely grammatical change, changing dates from plural to singular, which made more sense in the sentence in which it appeared. Second one had to do with the Victim Notification System Task Force. That was the provision that this committee put in regarding this task force to study victim notification generally. Are there automated proceedings that could be improved to provide better notification to victims? And the only change here is adding a member to the task force. So it's all the same except for the very bottom of the page, lines 20 and 21. It adds a member appointed by the Commissioner of Corrections who is familiar with the capability and technical operations of the VINE system. The VINE system is a acronym, stands for the Victim Information and Notification Every Day. Is this system? It's a national victim notification system that DOC uses and victims can sign up for. I think they download an app. They can register for notifications, and the Corrections Committee, I think they had an idea of who this person might be. Their general concern is to have someone familiar with these sort of IT issues who would be on this task force, since part of the purpose is to look at automated notification systems. So that's those two. Over to
Ken,
It's backing up.
yeah. Yep,
So this bind system we already have in process,
it's already being used, yes.
but I thought I heard testimony that victims weren't getting notified of releases.
Yeah, I think that's part of the concern is how efficient, how people can sign up for it. Is it being, what's effective? Is it being effective enough? So I think that's exactly right. That sometimes the notifications, the question is, can they be improved?
So does anybody even recollect hearing the Vine system before today?
Yeah. I don't think she called it VINE, but she called it the victim notification.
Okay.
It was the person that worked in the Franklin County Sheriff's Office, right?
No, that was, looking at that one.
Well, regardless, I'm just kind of surprised that we have another system in place that, whether it's outdated equipment or whatever, like so much of our antiquated equipment that we have that runs this state or supposed to run this state is not being utilized to full capacity or make an adjustment. Just an observation.
Angela.
I just, also backing up to, line 17 on page 1. I think that should read section 25.
Yes, thank you very much. Nice catch. There's a typo.
It was confusing, you know, why do we have 225A?
Thank you much. Anything more on those sections? All right, so now we're moving on to the fifth instance of amendment, page 3. This is the Adult Involuntary Guardianship Working Group that this committee put in the strike all amendment. You recall that working group is looking at the fact that you have two different court systems looking at involuntary adult guardianship, the probate division and the family division. And there's this working group that's going to look at whether or not, for the purposes of efficiency, they should be consolidated into one court proceeding, or whether or not, and this is the second point, the new language is subdivision D, lines 13 through 16, and it's really just chewing it up. That language was in the charge of the task force. This idea that not only would they be looking at whether or not there should be a consolidation of the proceedings into one court, or maybe another alternative would be, well, let's at least make the rights of access to voluntary guardianships be equal in both courts. So in other words, if you're going to keep it as two proceedings, let's equalize the rights for adults, access to voluntary guardianships. So this is just putting this in the report. See, if you look at line 5, this is the list of what the report shall address. It's just cut and paste of the same language from the charge, what the committee is supposed to look at, to what they have to include in the report. Request of Representative Donahue, if I remember correctly. Yeah. So that's that one. And then lastly, 6th instance of amendment, page 4. This is the Child and Parent Legal Representation Task Force the committee was talking about. It was yesterday, maybe it was last week with Chief Justice. Maybe that was Friday. Yeah. So one of the things it does here, you'll see, it has to do with the membership of that task force that's reporting on the need for improvements to the legal representation system for children and families involved in certain types of proceedings. So with the chief, you see line 7 designates the Chief Justice as the chair. So that's new language, shall be the chair. And then lastly, it adds 2 members, the last 2, numbers 8 and 9, the Attorney General or designee, and the Executive Director of the Departments of States Attorneys and Sheriffs or designee. So those are the 2 additions.
Any questions on that? We have one more issue to resolve, but yeah, fine.
At who, or did they request to be added?
Yes. Yes, requested to do that.
I missed the party.
Okay, so we are, the issue we still have to figure out is what to do as far as relief from abuse petitions in section 38, the Child and Parent Legal Representation Task Force report. Who wants to go first and talk to us about whether that should stay or go? I don't remember what order I had you in because I can't remember.
Some.
Why don't you join us first? And I apologize if I've messed up the order, but I didn't have the thing in front of me.
Good afternoon. Charlie Glisserman. I'm the policy director at the Vermont Network Against Domestic and Sexual Violence. I'm also joined here by Sarah Robinson, co-executive director, who has much more intimate knowledge of these systems than I do. So I may phone a friend. A new title.
Oh, not super.
Congratulations. It is very exciting. Very happy for her. So we appreciate the opportunity to share the Vermont Network's perspective on Section 39 of S-109. So while the primary scope of this child-parent legal representation task force is FINS cases, the current language also includes children and families who are involved in relief from abuse petitions. We really appreciate the committee's attention to legal representation and supports for children and families in CHINS cases, and also really appreciate the committee's attention to legal representation and supports in RFA cases. We feel like both of these conversations are very worthy, but they're very different conversations. And we believe that combining conversations about 2 complex issues, CHINS and DCF involved families and RFAs into one task force is not the best approach. So overall, these 2 issues involve different families, DCF involved families and those who are not DCF involved, different parts of the court system, family court and civil court. And because different people and different systems are implicated, there are different sets of stakeholders who we feel it would be important to have at the table and weigh in on policy recommendations related to these separate systems. And so that's why we are requesting that the committee remove the reference to relief from abuse petitions from the section. Very briefly, many families and children who pursue civil relief from abuse orders have no connection to DCF. So there's certainly a Venn diagram, but not a circle. The RFA process is designed to be a civil process where plaintiffs can use independent of any involvement with law enforcement or child protective services. And in some cases, DCF involvement can exacerbate safety concerns for certain victims. RFAs are designed to provide specific protection of victim requests. They are not designed to instigate involvement with any other system of support or protection outside of those requests. And so we feel that changes to the system require very careful consideration and stakeholder feedback to ensure that they are victim-led and don't unintentionally cause harm. Next, a little bit about the courts that we're operating in and who is providing legal representation within them. So the issue of legal representation in civil RFA cases doesn't necessarily belong in the same conversation about representation in family court. The Defender General's office does not represent parties in civil RFA cases, unlike in Chin's cases. And in his testimony, Marshall Paul noted that in confusion with the RFA language and the scope of the task force because of that. RFA petitioners are typically represented by private or pro bono counsel, like attorneys from the Vermont Network's legal clinic or legal aid that routinely represent families and RFAs on behalf of minors. And so overall, including RFAs in the scope of the task force would require a larger and different set of task force members. As an alternative, we've extended an offer to convene a group of stakeholders in the off session outside of this task force to examine legal representation and support for families in civil cases and explore potential solutions. We think this conversation can have special consideration for RFAs on behalf of minors and any potential to leverage Title 40 funds. So again, we are very committed to enhancing support for children and families who are victims of violence, and we feel that this is a very important conversation and are grateful to the committee for having this conversation here. We really want to set it up to be successful. And so we ask that if the committee does not accept our request to remove the RFA language from the section, that you clarify in the language that the task force is only speaking to RFA petitions on behalf of minors and not RFA petitions total. And we would also request that you add attorneys from the Vermont Network and Vermont Legal Aid to the task force membership, as they have, significant experience in RFAs and RFAs on behalf of minors. So we really appreciate your consideration and would be happy to answer any questions.
Well, you've given us a couple options from your perspective, so I appreciate that. Questions? No, I think we're good. Thank you very much.
Perfect, thank you.
So we'll hear from Amy next. And thank you for being here as well.
Thank you for the opportunity. So for the record, my name is Amy Rose. I am the Policy Director with Voices for Vermont's Children. Thank you for this opportunity to talk more in detail about relief from abuse orders or RFAs on behalf of minors in the context of F-109. I want to start by offering my gratitude for your collective work this session. Voices understands that RFAs filed on behalf of a minor are handled very differently than emergency care orders sought by the Family Services Division of DCF. We can see why the inclusion of them in this bill might seem unusual to some. It makes sense for the task force to primarily focus on Chin's cases, as the goal of the task force is to explore opportunities to draw down federal Title 4E funding in support of child, youth, and parent representation, and representation is not automatic when DCF is not involved in a case. Parents currently benefit from legal representation, and children benefit from both expressed interest representation from lawyers and the best interest representation, guardian ad litem's, in Chin's proceedings. Children are parties to Chin's proceedings, and their voices encouraged even in the most complicated of cases. This is because there's a significant amount of research that supports their involvement in decisions made on their behalf. Yet this practice is not consistent across court experiences in Vermont. Voices for Vermont's Children hears from parents and children who have concerns about the lack of child and youth representation in non-DCF family court proceedings with some frequency. We see this exploration of Title 4E as a potential opportunity to address this disparity. The Title 4E of the Social Security Act supplies grants to states for aid and services to needy families with children and for child welfare services. Part E of Title 4E supports federal payments for foster care, prevention, and permanency. The Families First Services Prevention Act of 2017 made significant changes to Title IV-E, allowing states to use federal funding for prevention services to support families and prevent the need for foster care placements. FFSPA creates a path for federal funding to match state dollars for pre-petition support and also for legal representation for children and parents who present a variety of risk factors. When a child has experienced harm to a degree in which someone files a relief from abuse order on their behalf, they would qualify under the at-risk of foster care criteria, and therefore could be eligible for Title IV-E support if our state chose to pursue it. This matters because without representation, children in the relief from abuse court process are rarely able to testify on their own behalf. The person filing this order is bound by traditional hearsay rules, which is unlike emergency care orders in the CHIN's docket. And therefore, it is very difficult to get enough evidence before the judge to grant an RFA on behalf of a minor. The data that I shared when I testified previously shows the disparity between the rates at which RFAs are granted for adults and children. This is a gap in our structure that we have been unable to resolve. It is important to acknowledge that DCF, the Parent-Child Representation Center, the Office of Child, Youth, and Family Advocate, Vermont Legal Aid, members of the Judiciary, GALs, the Kids Safe Collaborative, the Vermont Network, legislators, and others have been involved in numerous conversations about non-DCF family court cases. In addition, impacted people have offered their expertise generously because they want a better structure than the one they experienced. The work in this realm is vast, and it clearly extends beyond the scope of the task force. We agree and do not think that the task force will have the capacity or expertise to solve all of the issues at hand. We welcome and celebrate ongoing work outside of this task force. The task force has a specific mandate to look at the viability of an improved legal representation system for children and families who are involved in juvenile or administrative proceedings. It is our opinion that Title IV-E conversations would not be complete without naming opportunities to better serve young people at risk of foster care. It would also be helpful to take this opportunity to talk about the representation in a de-siloed way, especially since some of the RFA cases do overlap DCF cases. When we talk about systems reform, the important question of how will we fund this is necessary. Since DCF is ultimately responsible for our Title IV-E plan, this task force can help determine whether it is appropriate and worthwhile to access federal funding to support kids at risk of foster care and what it might take to do so. Voices still has a lot to learn in this area and is not clear on whether this is the right use of these resources at this time. We believe this task force will add to and help inform the many discussions that will continue to happen regarding representation for kids inside and outside of the traditional CHINS process. Voices recommends making it clear that the task force isn't charged with discussing representation for RFAs broadly, but instead focus on RFAs on behalf of a minor, as the task force will focus on cases that involve children. We see this as an opportunity to further discussion about what is working well and where there are opportunities to improve representation for children and their parents across structures. Voices leans into the expertise of our partners often and appreciates that we might have differences of opinion at time. It is healthy and it challenges us to approach the work with curiosity. Ultimately, we are all striving for a court system where everyone is informed and where people walk away feeling as though the system worked as intended, even if they disagree with the final outcome. This is an important component of the healing process. These cases are difficult and all parties involved are better off when the process is defined, consistent, and transparent. Ultimately, Voices is less concerned with where the work lands and more concerned with ensuring that it happens. We understand that there are some members of the task force who are not a part of the RFA process. We believe that it could be beneficial to hear how the different structures operate as we seek reform in both proceedings. We do agree as well about adding additional members to the task force to broaden the scope. Again, thank you for taking the time to discuss this important topic.
Thank you. No, thank you. Questions for Amy? Angel.
It might be a question for Eric, but well, yeah, so I actually both Charlie and Amy have used the word minors, and I just want to make sure if we move forward, you know, we always have that question of like children, minors, like make sure that we're
The right term.
based on statutory references and definitions that we're capturing the right group.
Right, right.
So I didn't know what that word, what that correct word would be. But so I think that's for legislative council, but I will ask you, Amy, do you think something like the language that Charlie shared, relief from abuse petitions on behalf of insert correct word here, minors, children, juveniles, whatever, probably not juveniles. Should we specify the bit about 4E funding, that is really the area of inquiry here, or
I think it's up to the committee to decide. I think much of the work of the task force is around that piece, and that would be the area that would be most relevant to the group that would be within the task force. So I think it could be helpful for clarity, but I don't think it's essential.
okay.
It isn't page 30. Divisions 2 and 3 of the task force referred to their power.
Yeah. Line 16 and 17 on 37, on page 37.
16 through 19. At least on my version. The 8.1.
Oh, I see, yes, wait. Okay, yeah, so I was just wondering if we should try to narrow the relief from abuse portion to just the Title VIII inquiry. Anyway, it might be, so don't.
So I think you and Charlie both raise really interesting points, and it makes me, it seems like it's really important to get at it and not dilute this. So I'm still kind of torn on what the answer is, and still feeling like there are other important stakeholders and questions related to foster care prevention. So you framing it that way was eye-opening to me. I'm thinking of BCRIP and all the kids who run away from home, and the legislation that we passed back in 16 or 17 related to 16-year-olds, I think, being able to file RFAs on their own, and trying to figure out if they have the adequate representation they need when they're going out on a limb to do that. And I get that people are not overlapping with DCF cases. So I started thinking about either what the network was saying, which feels like an unfunded mandate of a kind that, again, seems slightly narrower, or like having it would be really great to have a public hearing somewhere on this, because I think we just need to think really broadly and see how other states have really been able to fund foster care prevention efforts. Like, it could be an incredible opportunity for our state. And I would love to make sure we do that right. And just like we need to do this other issue right. So I don't know.
I'll respond if it's okay. I do think that there are many opportunities within Families First for broad prevention, and even funneling funding towards providers and really creative ways that does not necessarily link children to being drawn more deeply into the DCF system. Some of that has been held out because of the DCF data system and other barriers, right? And some of it is still continuing to be explored. I think this bill in particular is really focused on the representation piece, which could be very broad, right? It could offer services to many folks who we haven't had funding mechanisms to support in the past. And so my hope for this task force is, if we are going to spend the time together, is to create an opportunity where we're not limiting what we can talk about, so that we can share, it may not be the right time. We might not have the resources to do everything that we're hoping to do, but we can at least outline what is needed and sort of what the possibilities are. And
sort of next steps,
next
like,
steps.
right, like what we were charged with this, but here are the things that we found that we weren't able to fully.
And I see that as the biggest benefit of the prevention side, is the fact that we can expand the way we look at, helping to identify people's rights and make sure that they're clear about their process. And so I don't know, given the scope of the work, I don't know if we'll have a full comprehensive plan, but I would like to have the opportunity to talk about what would be needed. And I wouldn't want to cut valuable pieces out of the conversation if if they make sense to explore.
And is it appropriate for the Office of the Child Advocate to hear that that's a priority to look into and come back to us?
We can ask them to do that. I mean, just the RFA part or
Yeah,
broader?
well, I mean, I'm thinking of the RFA part because it definitely needs, and whether or not the language comes out in here, just like, could somebody be charged with trying to be thinking about next steps as well? Because who knows if this group could just be so busy getting part A done that I'd hate for part B to fall off. I don't know.
So, one of the options certainly I heard also is that there would be an informal meeting that you mentioned, and certainly could make sure that we request that the Office of Child Advocate be part of that. And I'd also request that they keep you in the loop. You don't have to, we're citizen legislators, but just actually knowing that it's happening.
Right.
That would be appreciated. Yeah, and coach, and if either of you are able to come monitor, sit in, again, don't have to but there's off session work.
Right. But like I'm thinking the network will have its hands full with its own work without taking on this huge thing too that we're not funded for. But
If I may just, we do see that as our work. And so, I don't think this is kind of asking us to do something that's outside of our scope. I think, looking at ways to improve RFA processes, including RFAs on behalf of minors, is really at the core of what we do. And it's something that we'd be really happy to support.
That's kind of where I would be leaning, but I am deferring to you and coach this one. So.
We're hearing from Larry, right?
Well, we still need to hear from Larry as well, if you want to weigh in on this to provide. So thank you very much.
We need the magic 8-ball.
Well,
Good evening and good night. I'm Larry Chris, the director of the Vermont Parent Representation Center. Thank you for the opportunity. There's a maxim I learned a number of years ago, that when there's a problem and people come together and talk about it, you sometimes come up with solutions, but not always. When you write a bill and put things in there that you propose are going to happen, miracles occur. You get all kinds of nice things. You get a decision to work on specific problems through the legislative process. And you also empower, if you would, groups not part of that, like the network, to do what it is they're saying that they had proposed to do this summer, if I'm correct in that, which is to look at this particular issue. One of the things that we have found out in preparation for today is that, in fact, 4E money can be used for RFAs, for children who fall into the broad category of foster care or requiring some kind of state service. So it seems to me that these two things could be done simultaneously. There will be a report that would come from the task force that's directed here that will reference, if the language stays in, will reference the 4E capabilities. And at the same time, the network would be pulling together the expertise to produce, I'm assuming, a game plan, another report as to how the RFA issue and probably larger issues associated with that are far beyond my expertise could be dealt with going forward. So VPRC supports either approach. I think either approach accomplishes what we had hoped to see happen with the legislation. So it's up to your wisdom as to how you want to proceed.
So I would throw out there as well that one of the big issues has been that the Defender General has been doing this work, and part of what we want to be looking at is how to support them or improve what they're doing or do something different. And the Defender General doesn't do the RFA stuff. And I think keeping it focused on that and this group with this guarantee that we're understanding that there's a separate informal group that will keep us in the loop. Kind of would be my wisdom, such as it is.
And
Yeah, I mean,
That's good.
I think that I feel this, I just want to make sure the work is being done.
yes,
And I understand that it's important to be done by the right people, but I think that that can be hard to determine, or you could, very caring, wise people could disagree on who the right people are. And so I just don't want to, if we take the language out, I just want to make sure that the work is being done.
What if if the language comes out, what if there's something that goes in that says, we understand that this work is not the only work that can get funded through this program. And we recognize that there are other dimensions that we still need to get input from, so that it's at least mentioned and not like forgotten.
Can I offer a suggestion that
Yeah,
might
please, go ahead.
sort of satisfy the pieces? I wonder if we reference the people at risk of foster care and the prevention piece, and it's not specifically named as RFAs on behalf of minors, but it's sort of space to explore people who are not already connected to the DCF system. And it wouldn't be required that we have to have concrete outcomes for that category, but that there's an opportunity to discuss it.
I guess I'd be a little concerned of doing it that way though, because that,
Defender General thing. I guess.
well, yeah, and it also kind of, I think I want to be specific somewhere, and I think we're trying to be specific on the record here on this request and what we've heard in testimony. And the fact is, I would assume that there's going to be some overlap in what the network would be looking at in an informal group that would include the Voices for Vermont's Children and presumably the Child and Youth and Family Advocate. It's not, I don't know that the Vermont Parent Representation Center needs to be part of that. Defender General doesn't need to be a part of that. Some others don't need to be a part of that. So that's kind of where I would suggest.
On our work list for next year that we're gonna.
Yeah, and the reason I want them to keep you in the loop as well is that if there's going to be any bill requests that are coming out of this as well.
Right.
So making that clear that we want that. Not that the network doesn't know where to find us for asking. Yeah, please, Sarah.
For the record, Sarah Robinson from the Vermont Network. I think wherever you land, it is up to you. And if the language comes out, I just want, again, to say for the record, it is our sincere commitment that we want to bring stakeholders together to talk about representation in RFAs for children and for adults. Like it's a big issue in terms of underrepresentation in RFAs. But we just do think it's a slightly different set of stakeholders. And so it would also, assist the committee. We've certainly had other committees send, for example, like a letter of intent or something that's non-legislative that just outlines your intent for those conversations. So that there's a mechanism for us to report back to outside of legislative language. And of course, we'd be more than happy to receive something like that. So just want to offer that as an option as well.
Yeah, no, that makes sense.
and I would just offer that I think that from our perspective makes perfect sense. And in fact, is very much in keeping with the intent of this process to make sure that the groups that needed to be involved were involved, but they don't necessarily have to be in the same room at the same time. And I would also add that the addition of the Attorney General's office and the state's attorney's department is actually a welcome addition, because each of those entities brings their own separate sets of expertise, and particularly around training and supervision. And that, in combination with what the Defender General's office has historically done, makes for, I think, a healthier mix of options that can be applied going forward. So thank you.
So are we good to take the relief or abuse order prevention out.
I have a question.
Yeah.
I'm not sure. I don't think I caught this in Charlie's testimony. Did you mention with the, you mentioned the addition of attorneys from the network and Vermont Legal Aid, was that if the language remains in?
Yeah.
Right.
All right, so just, yeah, go ahead.
Okay.
So, before we adjourn tomorrow morning, depending on how long the floor goes, Michelle will go over the hopefully not the penultimate, hopefully the ultimate S12 version. I don't think we'll be ready to vote on it, but maybe we will. Well, I'll take everybody's temperature on whether they want to. If they see it in the morning, are people going to be ready to vote on it in the afternoon? Because in the afternoon, we will do at least a straw poll on H98, which I'm going to ask for one legislative day delay, and H41, which apparently we're going to need to delay. Anything else?